What's the benefit of verdict versus a settlement? Is a settlement better than a verdict, or vice versa? My name is Daniel O'Toole. I'm a partner at Block, O'Toole & Murphy. I've been admitted to the practice of law in New York for the last 32 years. We're going to go through today the benefits of verdicts versus settlements and vice versa. What are the benefits of settlements? What makes them better sometimes than verdicts, and how verdicts can drive settlement values. So a verdict is the culmination of a personal injury lawsuit. It's the final voice of the jury on a case that's been tried completely. A trial consists of a number of different phases. The first is jury selection, and that is just what it sounds like. I will sit in a room with a bunch of strangers, potential jurors, along with my adversary, and we engage in a process that's called voir dire. It's a French term that means to look and to listen, and we do just that. We look at the potential jurors, we size them up, we have a questionnaire that gives us some biographical information on them. It's a great opportunity for me as a trial lawyer to try to connect with the people that are going to be the most important people in the case, which is the jury. They're what we call the judges of the facts, and they ultimately put a price tag on the case by saying, okay, we think that the injuries of Mr. Jones are worth X number of dollars or Y number of dollars, and they also determine whether the claimant is entitled to past lost wages, past medical bills, future lost wages, future medical bills. So they're very important people, obviously, and we don't get to meet them until jury selection. So I do my very best in jury selection to make a personal connection with the folks that are going to be the jurors on the case. After you get your jury selected, you sit down with the judge, and the judge tells you what law he or she is going to charge on the case. That's a pre-trial charging conference. And then you have the opportunity, both sides have the opportunity, to make what's called an opening statement. You have an opportunity as an attorney to tell your story. I open what I call big. I'm trying to win the case on my opening statement. So I don't hold back and act in a conservative way when I'm making an opening statement. I try my very best to connect powerfully with that jury from the moment I open my mouth. The other side gets an opportunity after I sit down to make their own opening statement, and then we put on witnesses. And again, because I, as the plaintiff attorney representing the injured claimant, have what's called the burden of proof, I go first, and I have to prove my case. In the civil case, which is what a personal injury lawsuit involves, the burden of proof is what's called the preponderance of the evidence. And it's not like a criminal case or a criminal trial you might see on TV or in a movie where it's beyond a reasonable doubt. It's different. Preponderance of the evidence is 50.001%, more likely than not. So that's our burden of proof. Direct testimony is when I ask a question of a witness. Sometimes it's the plaintiff is the first witness I put on the stand. And then when they give an answer, that's called evidence, because a question matched with an answer is evidence. There are two different types of witnesses. There's lay witnesses, which sounds like exactly what it is, folks that are not experts, regular civilians, the plaintiff, the defendant. And then there are expert testimony that comes in as well. In a personal injury lawsuit, expert testimony is largely comprised of medical testimony coming from treating physicians, maybe radiologists that read some of the diagnostic studies, and then expert testimony as well. Oftentimes on a personal injury case, I'll put what's called a life care planner on the stand. And because the injuries involved in many of our cases are permanent injuries that will span the entire lifespan of a client, we want to make sure that we take care of the client for the rest of their life. We're in a high inflationary time right now, and it's important that the jury has an expert opinion on what is anticipated to happen with medical costs over the lifespan of the claimant. So in every case I've tried in the last 25 years, I've had an economist come into court to talk about what medical specials are going to look like going forward. I've talked a bit about opening statement, I've talked about direct testimony, I've talked about lay witnesses and expert witnesses. So that's how you put on your trial. And then at the end of the evidence, and of course the defense gets the opportunity to put on their evidence as well, and we cross-examine their experts and their lay witnesses. That is, we ask them questions that we think will elicit testimony that makes the jury understand what the truth of the case is better. And then when all that is done, each side gets an opportunity to make what's called a summation. And in this case, the defendant goes first, they get to talk first, and I love this, I get to talk last, which is great. So if the defense says something in their summation that I think requires clarification or explanation, I have the opportunity to have the last word with the jury. If you've done your job well, and if you haven't violated the trust of the jury, God willing, they're going to be with you when it comes time for the verdict, which is how we started this discussion. So the end of a trial is the verdict. And the question, I guess, that a lot of people ask is, well, is that the end of the case? And unfortunately, it's many times just the beginning of the case. Settlement of a personal injury lawsuit is an agreement by both sides that in exchange for a certain amount of money, the lawsuit is going to end. On every case we have in the firm, we then write what we call a claims analysis letter. And in that letter, which is quite lengthy and quite detailed, we describe what we believe the evidence will be at trial, what the liability proofs will be, under the law, what facts benefit the plaintiff and ensure the plaintiff a good outcome. And then we do an analysis of the injuries involved, the sustainable value of that is what has happened in the past with similar injuries, what the appellate division has allowed to be paid on those type of injuries. And I think perhaps most important of all, we introduce the insurance companies to the individual we represent and let them know what it is about that person that makes them uniquely special. And I think that's something that we do differently and perhaps better than any other firm, which is we're great storytellers and we really know our clients. In many ways, verdicts and settlements are inextricably connected because the past great verdicts of the firm, and not just myself, other great lawyers at the firm as well, that drives settlement value today. So we use claim letters, we use a process that's called mediation, which is a sit down essentially between both sides of the case. We'll put on a presentation. Sometimes it'll be a very detailed PowerPoint presentation. I've gone for over an hour on my PowerPoint presentations. I want the insurance company, all the defense attorneys on the other side to know at the mediation that I could try the case to verdict the next day if I had to. The work has been done, I know exactly what I'm gonna do, and I show them all of my trial proofs. And the hope is that I'm scaring the daylights out of them and that they're saying, oh my gosh, you know what? We gotta get rid of this case. He's ready to try this case. And if we don't settle it now, it's gonna cost us more money down the road. What's nice about a settlement is that it gives finality and certainty to both sides. It allows my client to move on with their life and close the chapter of that story for them. The answer, like in many things in life, is it depends. Settlements and verdicts, they go together. It's almost always in the best interest of a client to settle a case, but it's got to be the right number. I wish I could tell you that after you're done celebrating a big verdict that everything works out perfectly for the client. Unfortunately, sometimes that's the beginning of what's called an appellate process. Every time a verdict is taken, and sometimes you read these articles in the paper and it says, you know, oh, $100 million verdict taken. The reader of that article might think, oh my gosh, that's great for the person who got hurt. He or she is going to get paid immediately. 99.9% of the time, that's not what happens. 99.99% of the time, there's going to be an appellate process whereby the defense, the insurance companies, or the hospital, or the city or state will take an appeal of the case. They'll say, this jury got it wrong. That's too much money. This should be knocked down. And because of a number of different factors, court congestion, backlogs, COVID, shortages of personnel, the time for an appeal in the state of New York is terribly long right now. The verdict can feel good for the ego of the plaintiff attorney who took the verdict, might feel good for a moment for the claimant, but sometimes it's not in the best interest of the client because it takes time, a long time after that, for them to get paid. If you or anyone you love has any questions about how a personal injury lawsuit is handled, feel free to call myself, Daniel O'Toole, at Block O'Toole and Murphy. Our telephone number is 212-736-5300. And you can visit our website at www.blockotoole.com. Look forward to speaking to you.